I'm gonna try not to pass out. Tasty.
Can you keep your guns if you also enjoy some ganja? In 2026, that question is before American courts. Thanks to a strange clash between evolving cannabis laws and gun laws, litigants are now asking, is it unconstitutional to take away your Second Amendment right because you smoke pot? This issue has sparked a high-profile Supreme Court case and a tangle of conflicting lower court rulings. It's a serious constitutional debate and one that's far from clear. I've spent my career litigating constitutional rights in federal courts, and I can tell you this. It's one of the more interesting collision of rights I've seen. So grab your popcorn or pop brownies and let's break down the battle of guns versus ganja in the courts. First, some background. Over the past decade, marijuana has gone mainstream. 38 states and counting have legalized cannabis for medical or recreational use. In fact, as of 2025, about half of U.S. states allow adult use recreational marijuana, and at least 40 states permit medical marijuana in some form. Culturally, lighting up a joint isn't as taboo as it once was. About 50% of Americans have tried pot, according to health data, but here's the rub. Under federal law, marijuana remains Schedule I controlled substance. It's illegal, period. And a 1968 federal law says if you're an unlawful user of any controlled substance, including state legal weed, you cannot possess firearms. In other words, as far as Washington, D.C. is concerned, you can't be both a cannabis consumer and a gun owner at the same time. Here's the math problem that's breaking the American legal system. About 32% of Americans own a firearm. Somewhere around 50 million Americans use marijuana in any given year. If you draw a Venn diagram of those two groups, you have millions of people in the middle. These are people who are law-abiding in their state. Maybe they have a medical card, or maybe they just live in a recreational state, but they are unlawful users to the feds. And here's the fundamental question. Can the government strip a fundamental constitutional right from around 50 million people because they engage in conduct that's deemed legal in many states? This all comes down to a little box on a form you might have seen. ATF Form 4473, question 21F. How's that for lawyer talk? It asks, are you an unlawful user of or addicted to marijuana or any depressant, stimulant, narcotic, drug, or any other controlled substance? If you smoke weed, even legally in your state, and you check no, you just committed perjury. If you check yes, no gun for you. It's a trap. This conflict has been largely theoretical for years. The federal ban was on the books, but not always strictly enforced against casual cannabis users. However, recent developments have brought the issue to a head. In 2022, the Supreme Court in the Bruin case set a new test for gun laws. Any firearm regulation must be deeply rooted in U.S. historical tradition to be constitutional. My firm has some experience in this as we've litigated test cases in the Second Circuit on this issue. That opened the door for challenges to modern gun restrictions, including the ban on gun ownership by marijuana users. So how does the Bruin test work? We have to analyze the history and tradition surrounding the issue. Basically, the government has to prove that in 1791, the Founding Fathers would have disarmed you for doing what you're doing.
Take it, Thomas Jefferson. But we find these truths to be self-evident. It goes puff, puff, pass. The next round you get skipped.
But here's the rub. In 1791, Americans drank a lot of rum. They used a variant of opium. Hemp was a major crop.
Come run and find me if you wanna get high, cause honestly I got the bombest, I cannot tell a lie.
2 days before signing the Constitution, in 1787, many delegates partied at a tavern, reportedly consumed 54 bottles of Madeira, 60 bottles of Claret, 8 bottles of whiskey, and 7 bowls of punch. That's enough booze to float a battleship.
Well spent, Ben Franklin got so high he forgot to be president.
Did George Washington walk around confiscating muskets from guys who had a little too much cider at the tavern? No. The history shows that we had laws against shooting while drunk. We had laws against carrying guns into sensitive places while drunk. But we didn't have laws that said because you drank last Friday, you can never own a gun again. Those are tough historical arguments for the federal government to be up against. For a long time, our government argued the position that if you touch the devil's lettuce, you are too irresponsible, too dangerous, and too unvirtuous to hold a Glock. With some fortune, courts across the country are now examining this situation. And now the highest court in the land, well, maybe the High Court, is weighing in on whether you can have your Second Amendment rights and your 420 rights at the same time.
It is the opinion of this court that the practice remains hella f***ing balls to the wall awesome. At that point, the decision seemed fairly certain.
The marquee case in this debate is United States versus Hemani, which the U.S. Supreme Court agreed to hear in late 2025. Here's the story. Ali Hemani is a Texas resident who enjoys marijuana. In 2023, he caught the attention of the FBI. An agent searching his home found a Glock 9mm handgun along with about 60 grams of cannabis, about the size of a chicken egg, and also found a bit of cocaine. That was enough for federal prosecutors to charge Hemani. Hemani's lawyers argued that applying this law to a state legal cannabis user violates his Second Amendment rights. And remarkably, the lower court sided with Hemani. A federal judge in Texas tossed out the gun charge, relying on prior Fifth Circuit ruling that had struck down a conviction under the same law because the government hadn't proven the defendant was actively or recently using drugs at the moment he possessed the gun. In other words, the Fifth Circuit Court of Appeals reasoned that a blanket ban on gun ownership for drug users went too far. At most, the law could bar someone from having a gun while they're high, but not forever just because they use drugs occasionally. When the Fifth Circuit upheld the dismissal of Hemani's indictment, it effectively said a cannabis user who isn't actually impaired at the time of possessing a firearm may still have Second Amendment protection. This created a direct conflict with other courts, and the U.S. Justice Department, under the Trump administration, wasn't happy. Despite generally being a pro-Second Amendment bunch, Trump's DOJ urged the Supreme Court to review the case and reinstate the charge. They argue that disarming a regular drug user is justifiable restrictions on gun rights. The Supreme Court took the case, and oral arguments are set for March of this year. It's worth noting that Hemani's case is a little bit unusual. Not only was he a habitual marijuana user, but the search also turned up cocaine, and prosecutors insinuated that he had ties to Iran's Islamic Revolutionary Guard Corps. We aren't just talking about vague rumors here. The government alleges that Hemani traveled to Iran to attend a celebration of life for General Qassem Soleimani, the terror leader killed by a U.S. drone strike. His mother was even caught on video allegedly praying her son would become a martyr like Soleimani. This isn't just a guy with a joint. The government is deliberately using, maybe manipulating, a case with potential national security threats to scare the court into upholding the gun ban related to drugs. So Hemani wasn't charged with terrorism or other drug dealing, just the gun possession. And his lawyers say those extra allegations are only tossed in to make him sound dangerous. Because of those odd facts, some gun rights advocates were actually nervous about Hemani being the test case for this important issue. They even urged the Supreme Court to consider a different case with more typical facts, like an average person who only uses marijuana, so that weed isn't lumped in with cocaine and other scarier drugs. Nonetheless, Hemani's case is the one on the docket, and it will decide if Americans who use marijuana and perhaps other drugs are among the people entitled to keep and bear arms under the Second Amendment. So you have a suspected terror sympathizer on one side and the entire legal cannabis industry on the other. It's the ultimate legal cage match. But the reason the Supreme Court had to step in wasn't just because of Hemani's vacation photos. It's because the lower courts have turned the Second Amendment into a map that looks like a fractured jigsaw puzzle. Let's examine the chaos.
Ready! Aim! Fire!
Why did the Supreme Court step in? Because across the country, courts have been all over the map on this guns and ganja issue. Depending on where you live, a cannabis user's right to a firearm has gotten very different treatment. Here's a quick rundown of how various federal appeals courts have ruled. It's a bit technical, but it shows the circuit split that the High Court now aims to resolve. So the Third Circuit, Pennsylvania, New Jersey, and the surrounding area, has considered U.S. v. Harris. There, the court upheld the marijuana gun ban by drawing an analogy to laws from the old days that disarmed people who were drunk or mentally ill were unfit to possess firearms. The judges admitted there's no colonial law explicitly taking guns from cannabis users, since cannabis use wasn't exactly common then. But they said close historical cousins count. The logic, like drunks or the dangerously mentally ill, frequent drug users might pose a risk due to an altered mental state, so it's reasonable to keep guns away from them. In short, the Third Circuit treated habitual pot smokers as potentially dangerous by analogy, even if they aren't high 24/7. But let's turn to the Fifth Circuit, Texas, and Louisiana, Mississippi. The Fifth Circuit has taken the opposite approach, setting the highest bar for disarming a cannabis user. In cases like U.S. v. Daniels and U.S. v. Connolly and now Hemani, the Fifth Circuit said the government must show the person was actively intoxicated at the time of gun possession to justify taking their gun rights. It's not enough that someone occasionally uses marijuana. If they weren't stoned with a firearm in hand, the historical analogies, like laws against firing arms while drunk, don't match up. As one Fifth Circuit opinion noted, 18 U.S.C. 922 G3 goes much further than old laws by banning all possession by any unlawful drug user, even when they're not intoxicated. The Fifth Circuit overturned convictions and charges where there was no evidence the person was high while armed, effectively protecting gun rights for sober cannabis users. Right now, the Fifth Circuit standard is the most friendly to gun owners who partake in pot. Let's move on to the Eighth Circuit, Midwestern states. The Eighth Circuit's view has evolved. Initially in U.S. v. Beasley, it rejected a broad facial challenge to the law, meaning it didn't strike down the law entirely. But in later cases like U.S. v. Cooper and U.S. v. Cordova-Perez, the Eighth Circuit embraced as-applied challenges for specific individuals. These judges said not all drug users are akin to violent felons or lunatics. The government must show that a particular person's marijuana use made them dangerous or incapable of safely handling a gun. In Cooper, for example, they asked, did using marijuana make this person act like someone both mentally ill and dangerous? If not, prosecuting him under the gun law would violate the Second Amendment. The Eighth Circuit even vacated a conviction and sent it back, suggesting a jury might need to decide if the defendant's cannabis use actually made him a danger to others. Bottom line, in the Eighth Circuit, marijuana use alone doesn't automatically void your gun rights. There needs to be evidence that the drug use created a real risk of harm. Let's jump into the 11th Circuit, Southeastern states. In a case brought by Florida officials on behalf of medical marijuana patients, the 11th Circuit took a sympathetic view to lawful cannabis users in Freed v. Garland. The court noted that these patients were following state law, and there was zero indication that their marijuana use made them violent or irresponsible. The government had tried to compare them to felons or dangerous persons in history, but the 11th Circuit wasn't buying it. Simply using doctor-approved cannabis doesn't put someone in those categories. This was a big win for medical cannabis patients who want to own guns. The case was sent back to proceed, recognizing they might indeed have a valid Second Amendment claim. As you can figure out, it's a legal patchwork. In some parts of the country, any cannabis use could make you a prohibited person for guns. In other parts, you might be okay unless you were high while armed. Some courts demand individualized proof of danger, others uphold a broad ban. This kind of inconsistency, where your constitutional right depends on your zip code, often prompts the Supreme Court to step in. The justices generally want one clear rule for the whole country. So they took the Hemani case to resolve this four-way circuit conflict. By mid-2026, we should finally know. Will the Supreme Court let cannabis users bear arms, or will it uphold the federal law?
Smoking the soul-destroying reefer, they find a moment.
Let's break down the clash in philosophy here, because it's a poignant showdown between public safety concerns and individual rights with a dash of culture war. On one side, you have the federal government and anti-cannabis advocates arguing to keep the ban. Their reasoning goes like this. Habitual drug users are dangerous, or at least more likely to be dangerous, so disarming them is just common sense. The Justice Department points out that people who use illegal drugs pose a greater danger with guns than the average person, even more so than people who use alcohol. Some might find that claim debatable, given how often alcohol is linked to violence, but that's their stance. Historically, the government says we've kept guns away from groups seen as risky or irresponsible, like the mentally ill or intoxicated folks or felons. Why should chronic marijuana users be any different? In fact, an organization called Smart Approaches to Marijuana, SAM, argued in an amicus brief that marijuana has a causal relationship with mental illness and violence, so marijuana users as a class shouldn't have firearms. To be blunt, this side of the debate sounds like an echo of Reefer Madness-era fears, portraying the stereotypical stoner as one toke away from insanity or mayhem. 19 state attorney generals, mostly from states that are less cannabis-friendly, even joined a brief supporting the gun ban, essentially saying federal law is right to presume drug users are too dangerous to be armed. The underlying notion is that the Second Amendment, like other rights, isn't unlimited. And if someone's judgment is impaired by substances, the founders wouldn't have trusted them with guns. On the other side, you have a curious coalition of gun rights organizations and cannabis reform advocates. They argue that the government stance is outdated, unfair, and unsupported by history. For one, they note there's zero historical precedent for the federal law in the founding era. There were no colonial statutes saying if you smoke hemp, you lose your musket.
Hey, look at that back off. Trace!
The closest analogies, drunkenness as an example, are not the same as having used marijuana at some point. In today's context, they emphasize how common and socially accepted cannabis has become. Millions of Americans use marijuana, often lawfully under state laws, and they're otherwise law-abiding citizens. Does the government really think all these people are violent or irresponsible? Gun rights proponents like the Second Amendment Foundation and others say it's wrong and unconstitutional to lump a casual or medical marijuana user in the same category as a hardcore criminal. As one legalization advocate quipped, it's a very unreasonable position to label anyone who's ever used cannabis as a dangerous drug abuser who should be stripped of their gun rights. And there's some empirical skepticism. Is there solid evidence that cannabis users as a group pose a higher risk of violence? Many would argue alcohol is far more closely linked to aggression than marijuana, yet alcohol users aren't categorically banned from owning guns. The pro-cannabis side also invokes the Bruin test. Unless the government can find a strong historical tradition of disarming people like Hemani, peaceable citizens who happen to use weed, then the law fails the Second Amendment standard. And so far, the analogies offered, disarming the mentally ill, for example, haven't been very convincing to several courts. The underlying argument goes smoking a pot in your free time, especially in a state where it's legal, shouldn't automatically cost you your right to defend yourself. There needs to be actual evidence of danger or impairment, or as the 11th Circuit put it, you can't just assume medical marijuana patients are like felons. There's no tradition of taking guns from citizens who aren't dangerous. And here's the ultimate irony. The Justice Department fighting to keep this gun ban is the same department that secured a conviction against a former president's son, Hunter Biden, for, you guessed it, buying a gun while addicted to drugs. So we have a Republican administration effectively defending a law that convicted a Democrat's son, while gun rights groups who usually love the GOP are fighting against the ban. Politics makes for strange bedfellows, but guns and weed make for the strangest of all. To illustrate the divide, the government's ideal scenario is a world where if you want to own guns, you must abstain from illegal drugs entirely. They argue that's a reasonable rule to keep society safe. The challenger's ideal scenario is one where a responsible gun owner can also responsibly use cannabis, just as one might responsibly use prescription meds or enjoy a drink without forfeiting their Second Amendment rights. No one is saying you should mix guns and intoxication at the same time. Every side agrees about that. The question is, what about a person who uses cannabis one day and goes to the shooting range the next perfectly sober? Should the law treat that person as a felon? The outcome of Hemani's case will answer that. While the gun issue takes the spotlight, 2026 will see a few other notable cannabis-related legal battles worth a quick mention. Here are some other points of tension. We'll just give them a passing glance today. Tax fights. Cannabis businesses are grappling with a punishing federal tax rule. Under Internal Revenue Code Section 280E, any business trafficking in Schedule 1 or 2 drugs, think cocaine, heroin, and yes, cannabis, can't deduct normal business expenses on their federal taxes. This means state legal dispensaries get taxed on gross income, which can make their tax bills sky high. It's essentially a punitive tax policy left over from the days when all marijuana was illicit. In 2026, a case in the U.S. tax court is set to challenge whether the feds can continue treating cannabis as Schedule 1 for tax purposes. Well, let's move on to labor peace laws. Some states have begun requiring cannabis companies to sign labor peace agreements with unions as a condition of getting or keeping their license. These agreements typically force the employer to remain neutral during any union organizing effort and often give union reps access to the workplace. Supporters say that these agreements help prevent labor disputes in a booming new industry. Critics say they strong-arm businesses and workers into union relationships. In California, for example, licensed marijuana retailers must agree not to oppose unionization and even ban certain anti-union actions. This has prompted a constitutional challenge now before the Ninth Circuit. Opponents, like the National Right to Work Foundation, argue that these state agreement mandates are preempted by federal labor law and even violate employers' and employees' First Amendment associational rights. A federal judge in Oregon already struck down a similar requirement, calling it unconstitutional, and now the issue's on appeal. The outcome will determine if states can impose union-friendly rules on the cannabis industry, or if such labor requirements will go up in smoke. License residency rules. Early in-state legalization, many states tried to give their own residents a leg up. For instance, only state residents could get cannabis business licenses or majority ownership. This protectionist approach has been challenged under the Constitution's Dormant Commerce Clause, which generally prohibits states from discriminating against or unduly burdening interstate commerce. Here's the wrinkle. Cannabis is federally illegal, so there's a debate whether the Dormant Commerce Clause even applies to state legal marijuana markets. We now have a circuit split on this. In 2025, the Ninth Circuit ruled that the Dormant Commerce Clause doesn't apply to cannabis licensing because Congress hasn't made marijuana commerce illegal nationwide. Essentially, they said states can favor locals since, in theory, there's no lawful national marijuana market to protect. But earlier in 2025, the Second Circuit in New York took the opposite view, holding that even an illicit market can trigger Dormant Commerce Clause scrutiny, striking down New York's residency preference for licenses as unconstitutional discrimination. Meanwhile, other lawsuits in Michigan, Missouri, some other places are pressing this issue. It's a wonky legal debate, but an important one for the industry. It will affect whether new markets can keep outsiders at bay or must open up licensing to out-of-state investors. If the split persists, the Supreme Court may eventually need to resolve this as well. As you can see, the legal landscape around marijuana is in flux on multiple fronts, from how it's taxed, to how its business operates with labor, to who gets to profit. Cannabis may be more accepted culturally and at the state level, but in the courtroom, it's still stirring up fights that test the boundaries of federalism, economics, and individual rights. Back to the big question of the day. Can Americans have both their 420 and their Second Amendment, or can you enjoy cannabis and still exercise your constitutional right to own a gun? The Supreme Court's upcoming decision in the Hemani case should give us an answer. If the court sides with the government, then marijuana users, even occasional ones, will remain under a federal firearms disability, meaning they technically have to choose between their legal bud and their bullets. If the court sides with Hemani and others like him, it could lift that blanket prohibition, effectively recognizing that a state legal cannabis user is not automatically a dangerous outlaw who must be disarmed.
What are you boys gonna talk about?
How it's bullshit that weed stuff's illegal. Yeah, I mean, as long as nobody's being hurt, what gives you the right to go around and tell people how to live their lives?
Well, that's rich, coming from a Confederate.
You're the f***ing Confederate.
You're the f***ing Confederate!
Such a ruling would be celebrated by gun rights and cannabis rights advocates alike, and would mark yet another shift in the legal status of marijuana in America. Importantly, whatever happens, it's likely to be a nuanced decision. Don't expect the Supreme Court to say it's fine to blaze away while literally holding a gun. Even the most libertarian folks agree that guns and impairment don't mix well. But they might say, for instance, that habitual marijuana use by itself is not enough to cost you your Second Amendment rights, unless there's specific evidence of dangerous behavior. That would align with how some lower courts, like the 5th, 8th, 11th Circuits, see it. On the flip side, the court could uphold the law and basically tell Congress, if you think it's outdated in an era of legal weed, you go and fix it. Interestingly, a political solution could also emerge. There's a movement under the administrative rulemaking process to move marijuana from Schedule 1 to Schedule 3, but that will take time to do. For now, all eyes are on the Supreme Court. It's a case that blends America's gun culture with its rapidly evolving drug culture, a true sign of the times. And it puts a spotlight on a broader theme. How do our laws adapt when yesterday's crimes, like smoking pot, become today's normal behavior? Do we update the way we enforce other laws, like gun regulations, to match the new reality? Or do we hold the line based on older notions of morality and danger? So stay tuned for the court's decision. We'll find out if 2026 becomes the year of high rights at the court. Will it be a victory for those who believe in liberty and THC for all? Or a reaffirmation of the government's power to keep guns out of the hands of anyone who touches the devil's lettuce? Until then, remember, in the eyes of the feds, that gummy you're about to pop, it could be as dangerous as a hand grenade.